From 1964, conservatives have been trying to take a majority of the Supreme Court just so they could repeal the Civil Rights Act of 64, repeal voting rights in 65, repeal public accommodation, repeal fair housing, all those things. They sat and waiting for 60 years for just a moment. And all that it took was Mitch McConnell to just not give Merrick Garland a meeting and then wait. And then by that, they were able to get the 6-3 majority that they have today. And we're seeing the rollback of affirmative action, the rollback of student loan reform, the rollback of women's rights. So, Melanie, what should be the marching orders when we're talking to people now to tell them that, to have some hope and the plan to fight back against this? Because many people are just going to say, well, as long as they have that 6-3 majority, there's no point in us even doing anything because they're just going to strike it down on judicial review.
One, have the faith that just because you don't see the change coming, it's still coming. And that's what our ancestors and our predecessors taught us. So have the faith to know that this is not going to be always. And also faith without works is what? Dead. So we have to have the faith. And because I believe there's a spiritual warfare, that's my opinion. There's also spiritual, there's some wickedness going on in that building. And so we have to make sure that we look at that. But also, the election is around the corner. Some things are what they are. There's a presidential election. There's a congressional elections. There are also elections in these states. And we have numbers that we've still not maximized. It does not mean that we're going to win every battle at the ballot box. But it is still the strongest mechanism that we have. With all of the problems that go with it and all of the barriers, we still found a way to elect. The black vote really did drive that vote in 2020. That's why there's a Biden-Harris administration. We also stopped, and not alone, there are allies and others, but we have to use that. And we have to build those kind of, Reverend Barber talks about it all the time, fusion politics, how we have to fuse our movements together. Because the attacks on LGBTQ folks, attack on black and brown folks, attack. Well, if enough of us are being attacked and we find a way to bring those movements together, then we're that much of a stronger force. I don't know what it's going to take for poor white folks to figure out that they're voting against their own interests. I come out of Florida where a whole lot of mess is going on, right? Grew up in Mims, Florida. So, even in what's happening in Florida, if you look at the demographics, the numbers are there. The challenge we have, because you have a Supreme Court that seems to be in line. And this is where what they did with redistricting, I always felt like it was like, they were just like, okay, because we're looking so bad, we better not be so bad, because I just knew it was going to be bad, and it was, unfortunately. But the next president that gets elected could put 2 or 3 more people on that bench. Only God knows. Change happens, right? And so when you least expect it, so we have to be ready. We have to use those tools. So next year's election, we have to start organizing now. We have to engage. I know it's important that we engage our brothers and our sisters, right, to be able to know that we own our power, and we can make that difference if we come together also across other kinds of movements together.
And diving deeper into the student loan forgiveness case, Abdul, I wanted to bring you in because I thought that this case would not get decided on the merits because they never established standing. The 5 or the 6 Republican attorneys general who brought the suit under normal circumstances would not have standing. They're not parties to the case. They were not harmed by the case. Can you explain this public interest or this public question doctrine that the Supreme Court used in order to establish standing to even be able to rule on this?
You're absolutely right. One of the things that we have seen this term is that in some respects, the Supreme Court has almost obliterated the doctrine of standing, right? I mean, the reality here is that you do need a particularized injury in order to claim standing. And it's unclear here what the particularized injury here is that allowed the court to reach the merits on this decision. There was a lot of hand-wringing, a lot of nuance, a lot of parsing by the Chief Justice in order to get to the merits, because clearly they wanted to decide on the merits. And ultimately they did. And I think we have to be mindful that the way they got to the merits here is through this doctrine, which really is a made-up doctrine, called the Major Questions Doctrine. And essentially what the Major Questions Doctrine says is it allows the court essentially to blunt the authority of the administrative agencies to act broadly when given that delegation by the Congress. And that's exactly what they employed here to blunt the action of the administrative agencies who clearly on the text of the statute had the authority to act to forgive student loans.
And Matt, I want to bring you in on this point, because the other thing that did not quite make sense was during COVID, Betsy DeVos used the HEROES Act to delay student loan payments. That's well established, nothing controversial around it. President Biden used the exact same HEROES Act. And for people who don't know, HEROES Act was passed after 9/11, so that people who were either impacted by 9/11 or who were deployed during the war on terror could have their student loans either deferred or forgiven. So not bankrupt people who are being affected by a national emergency. The law was codified into law by Congress, and therefore, when COVID hit, you can use that exact same act. The natural disaster this time is COVID as opposed to 9/11, in order to change or alter the student loan repayment process. That's not controversial. How did they get to the point of trying to parse out that somehow what President Biden is doing is different than what Betsy DeVos just did?
Well, because they don't like it now. They liked it when she did it. It was okay if she did it, and now it's a problem. I mean, that's really basically all it is what it comes down to. And I think this is another example of, unfortunately, the Supreme Court getting where they wanted to go by virtue of whatever vehicle they have to make up to do that. I think Abdul is 100% right with the Major Questions Doctrine, because the statute, from my understanding, is pretty exceedingly clear. National emergency. This is a national emergency. The executive branch can employ whatever it means it wants to respond to that as it relates to student loans and the cessation of payments. So it's a pretty basic thing. And the question you didn't ask me that I nonetheless want to answer is, I think this is indicative of a crisis point we see in the country, where the Supreme Court is increasingly out of sync, obviously, with what average people want. But if I were a person who weren't a lawyer, I would be like, what do these people exist for, right? Like, government exists to help me, to provide services. And all they do is continue telling me why I'm not going to get services, or why certain things that could help my life be measurably better are somehow, because of some obscure legal doctrine that they come up with, not going to be implemented. And I say all of that to say I'm wondering where this is going to leave us going forward, because we know the Supreme Court already has the lowest level of trust it's had in years with the American public. And it's starting to get to the point where it's just kind of like, what is the point? At this point, the rights that have given us certain ways to move through the world are being rescinded, and being rescinded at lightning pace. And I'm wondering what the measurable effect of that is going to be, because that is going to continue fomenting distrust in government and in the Supreme Court in particular.
I think back to the Warren Court. When they were passing Brown versus Board of Education, Chief Justice Warren fought to have a unanimous verdict, because he understood how important it was to the legitimacy of the court, that people understood that the entire court was united in desegregating schools. The same thing that John Jay said, the first Supreme Court Chief Justice, where he talked about the fact that the court does not have troops, the court does not have an enforcement mechanism. The only thing that they have is the trust of the American people and the belief that they are going to be a non-biased tribunal answering the laws. When John Roberts was being confirmed, he said, I'm a neutral umpire. I call balls and I call strikes. These are legislators who are on the bench. And Republicans have said for years they do not want activist judges on the bench. They want to make sure that there is just simply going to be the law and nothing else. But now they are legislating from the bench. Michael, before we go to break, what is your take on the legitimacy of the court going forward? It was shaken by Bush v. Gore 2 decades ago, and it seems to be shattered now.
Well, you have people like Leonard Leo, you have the Heritage Foundation, you have the Federalist Society, and this all ties into the long game and them really making up laws making up the rules as they go along. But they're playing for keeps. They're playing for control of the federal bench and the U.S. Supreme Court for the next 25, 30 years. And very quickly, when Melanie Campbell was speaking, and when Madam Vice President was speaking, we have to understand how to protect gains that have been made. One, how to assess gains. Two, how to protect gains. It's not only about what an an elected official, politician can do for you is also understanding who will protect what has already been done to help you as well. Okay, so Shelby County versus Holder, U.S. Supreme Court case 2013, and that played a big part in the 2016 presidential election because there were 868 fewer polling places in the U.S. because right after that verdict, you had states started passing these voter ID laws and start closing voter polls, and a lot of those voter polls that were closed were in African American communities. And lastly, on student loan forgiveness, that would have greatly helped African Americans. African American women have almost 2/3 of the $1.7 trillion student loan debt. Okay, that executive order would have moved 500,000 African American families from a negative net worth to a positive net worth. So you look at the venom coming from Republicans trying to strike this down. We have to vote these crazy people out of power and make sure they don't get back into power.
And Kelly, real quick, just on Michael's point, the president announced today he will be taking remediary measures. He's going to attempt to cancel student loan debt through the Higher Education Act of 1958, that he will be suspending reporting of past due student loan payments to credit bureaus for 12 months. He made the deal with Kevin McCarthy saying, well, I'll restart payments in 60 days. But then he said, well, look, I said I'll restart payments. I didn't say I'll restart collections. Kevin McCarthy got hustled. But what is that going to be enough going forward, or do we really need legislative action on student loan reform?
I think when it comes down to it, we are going to need legislation on every damn thing, because we cannot trust the courts to interpret the laws as they stand, and we cannot rely on the executive powers that the president has because they are so fleeting. We need legislation. That is the whole point of the legislative branch, to codify policy, to codify law. And that is not what's happening right now because of, frankly, people just not wanting to do their job. Now, while everybody is really focused on student loan relief and the like, especially with this Supreme Court case that came down, while that was troubling, my biggest concern was the case regarding the LGBTQ rights in this country, because what that did was a slippery slope into Jim Crow 2.0.
Well, we're going to talk about that on the other side of the break.
I know we're going to talk into that, and I'm not going to go into it right now because I know we got to go to break, but the student loan thing will resolve itself eventually because something's got to give. And what's not going to give is my coins, and I say that proverbially, like if I got to pay, I got to pay. But as a collective, this is not going to get paid back. It's virtually infeasible in the way that this economy has been structured right now for us to pay back $35K, $50K, in my case, almost $250K. Thank you, law degree. So all of that to say, yes, the legislation needs to happen because the alternative cannot happen.